morning, everybody. Thank you for being here today. We are very proud and honored to host this event today. Before introducing our distinguished speaker today, please allow me to acknowledge and thank the presence of Professor Daniel Sapsay, President of the Argentine Association of Constitutional Law, Professor Alberto Bianchi, member of the National Academy of Law and Social Sciences, Professor Estela Sacristan, director of our program of postgraduate programs on constitutional law, and many other distinguished colleagues and friends. Professor Lawrence Solum is Carmack Waterhouse Professor of Law at Georgetown University since 2011. He holds both a BA degree at University of California in Los Angeles with an honors degree in philosophy, a JD at Harvard University, magna cum laude. He was an editor of the Harvard Law Review. He has been teaching, researching, and publishing extensively on several different very complex and interesting topics, including artificial intelligence, civil procedure, legal theory, constitutional theory, and of course, constitutional interpretation. He runs probably the most important law blog in the internet, which you must consult every day, like I do, the Legal Theory blog. He was nominated top 20 among the most influential scholars in the United States, and he is certainly the most important scholar in connection with the new originalism theory of constitutional interpretation. So Larry, we are happy to have you here today. The floor is all yours.
Great. So thank you very much. I'm going to just start my timer. Thank you very much. I am extremely grateful to all of you for coming, and to Manuel Garcia Mancia, who has been a very generous host. I am extraordinarily appreciative of all the work that he has done to make it possible for me to give a series of lectures here in Argentina. So my talk is about originalism and the Constitution of Argentina. I'm going to start with just a little tiny bit of the history of originalism. I'm then going to discuss 4 important ideas associated with the new originalism. And then I'm going to talk about some examples. We'll see how the time goes, but at least one example from American constitutional law, and then one example relating to the Constitution of Argentina. So the history of originalism. The basic idea of originalism is that the original public meaning of the constitutional text should be binding, that constitutional actors are obligated to make decisions that are consistent with the original meaning of the text. That idea goes back all the way. Originalist interpretations appear in the jurisprudence of the United States Supreme Court, and also importantly in the jurisprudence of the state or provincial Supreme Courts in the United States at the very beginning. But originalism became a topic of a special concern as a result of developments during the New Deal, during the presidency of Franklin Delano Roosevelt Jr., following the Great Depression, and in the Warren Court, the period when the Supreme Court was headed by Chief Justice Earl Warren. It was during this period that many critics of the court came to believe that the Supreme Court no longer considered itself bound by the constitutional text. That is, that the Supreme Court was engaging in a living constitutionalism that permitted judicial decisions that had the same effect as a constitutional amendment, that overrode or modified the constitutional text. This resulted in criticisms of the Warren Court and the rise of an early form of originalism, so-called original intentions originalism, that focused on the framers and their beliefs and expectations. Paul Brest, a constitutional law professor, coined the term originalism to name the critics, and that then new word stuck. It became the name of a new theory that later developed in response to the criticisms of Brest and others. One of the most important developments in the history of originalism is a speech given by Justice Antonin Scalia of the United States Supreme Court in the mid-1980s, in which he urged the early originalists working in the Department of Justice to abandon the doctrine of original intent and instead turn to public meaning, to the original public meaning of the constitutional text. And so originalism since the mid-1980s has primarily been a form of textualism, a theory that focuses on the meaning of the constitutional text. Contemporary originalism focuses on many ideas, but the following four are the most important. First, the fixation thesis. So the fixation thesis is the idea that the meaning of the text, or the linguistic meaning in context, or even more precisely, the communicative content of the text, the set of propositions or ideas that are conveyed by the text. The meaning of the text is fixed at the time each provision is framed and ratified. The meaning itself does not change. So, for example, in 1787, Article 4 of the United States Constitution authorizes the national government to intervene on behalf of the states, the provinces, in the case of domestic violence. Today, because of linguistic drift, the phrase domestic violence has acquired a new meaning. Domestic violence now refers to violence within a family. Spouse abuse, elder abuse, child abuse. But that was not the meaning of that phrase in 1787. At that time, it referred to rebellions, insurrections, and riots within the territory of a state. So if we want to know what Article 4 means, we ought to look at the linguistic practices of 1787 and not the linguistic practices of the 21st century. Argentina, like the United States, has an old constitution. So the Constitution of 1853 was written many, many decades ago. And so the meaning of the terms in 1853 is not necessarily identical to the meaning of the terms today. The second idea is the constraint principle. So the constraint principle is the idea that constitutional practice, including the decisions of judges, the decisions of the Supreme Court, must be consistent with and fairly traceable to the original meaning of the constitutional text. In other words, the Supreme Court may not decide cases or articulate constitutional doctrines that are inconsistent with the text, that contradict the text, that would have the same effect as a constitutional amendment. And the Supreme Court also may not make up things that are not fairly traceable to the text. So of course, not everything a court does is identical to the text. There have to be implementing rules or precisifications of constitutional provisions that are underdeterminate, that are vague or open-textured. But such precisifications or implementing rules are only permissible if they implement the text, if they are fairly traceable to the text. The fixation thesis is an empirical claim. It's a claim about how language works. The constraint principle is a normative claim. It must be justified by normative arguments, by arguments of moral or political philosophy. So I think there are two strands of justification for the constraint principle that are the most important. The first justification for the constraint principle focuses on the idea of the rule of law. So the rule of law is a complex idea. One way that the constraint principle advances the rule of law can be explained in terms of the rule of law values, stability of the law, certainty of the law, publicity or knowability of the law, consistency of the law. These values are better served by a constitutional practice that is constrained by the constitutional text if we compare that to the alternative, forms of living constitutionalism with an unconstrained Supreme Court that is free to change the Constitution at any time it wishes to do so. There is another and perhaps more important reason that the constraint principle serves the rule of law values. Without constraint, the Supreme Court inevitably will translate the beliefs, the values, the morality, the political ideology of the justices into principles of constitutional law. At some point, the political system, the president, the Senate, will realize what is going on. They will come to understand that the justices of the Supreme Court, unconstrained by the constitutional text, are politicians in robes, that they are a super legislature, making rather than applying constitutional law. But a special kind of legislature, a super legislature, because the decisions of the Supreme Court have the power to invalidate the decisions made by the President or by the Congress. Once you know this, then it becomes apparent that it's very important to control the Supreme Court, to politicize the Supreme Court. And this process of politicization has certainly occurred in the United States over the course of the last 3 decades. There's been an escalating battle in the Senate and between the Senate and the presidency for political control of the Supreme Court. The most recent development include the decision by the Republican-controlled Senate to block President Obama's nomination of Merrick Garland, a very fine judge on the District of Columbia Court of Appeals, for a seat on the Supreme Court. That move by the Republicans has resulted in discussion of court packing. So 6 of the Democratic candidates for President of the United States have endorsed court packing, the expansion of the Supreme Court to tilt the balance from Republican-appointed justices to Democrat-appointed justices. The Attorney General under President Obama, Eric Holder, has endorsed court packing. This would have been inconceivable in the United States. In fact, I have friends who wrote just 1 year ago that it is inconceivable that there would be court packing, but it is clearly no longer the case. I think that in Argentina you have a history in which court packing has played a role. And please, I know also that in Argentina, one thing that has happened is that a new administration comes in and impeaches all the justices of the Supreme Court. Don't tell your friends in the United States about this possibility. This has not yet occurred to the Democratic nominees for president, but if it were suggested to them, it might. Once this process of politicization of the Supreme Court is started, I believe that it leads to a downward spiral of politicization in which the political actors take escalating steps to attempt to turn the Supreme Court into a political institution. I think that many of my colleagues in the United States do not understand how dangerous a downward spiral of politicization can be. The second justification for the constraint principle focuses on the idea of legitimacy. So legitimacy is a complex, multidimensional concept. I want to talk about two aspects or dimensions of legitimacy. The first is democratic legitimacy. So the United States Constitution, the original Constitution of 1787, was ratified by a process that was intensely democratic by the standards of the time. Ordinary citizens participated in this process in town meetings. The ratification itself occurred in popularly elected ratifying conventions. Amendments to the Constitution must be approved by a supermajoritarian process, 2/3 of the Senate, 2/3 of the House of Representatives, 3/4 of the state legislatures. So all amendments to the Constitution enjoy very wide and deep democratic support. By way of contrast, a living constitution in the hands of a Supreme Court is a profoundly undemocratic mechanism for constitutional amendment. The Supreme Court in the United States consists of only 9 persons. 5 of the 9 can change the Constitution in a living constitutionalist regime. The 9 justices of the Supreme Court are not representative of the American people as a whole. For example, all 9 went to law school at Harvard and Yale. They are all drawn from the most elite segments of American society. This is not a group that is representative of the American people. They serve for life terms. Increasingly, they are appointed at younger and younger ages. It used to be that Supreme Court justices would be appointed in their 60s. That would no longer happen. No one will appoint a Supreme Court justice now who's older than about 50. And I think that it's highly likely that that age will be pushed back if it's politically feasible to do so. So it's an undemocratic system. If we compare living constitutionalism to originalism, to a constrained court, the constraint principle provides more democratic legitimacy than does living constitutionalism. Now, I don't want to be overly optimistic about the democracy of originalism. much of the history of the United States includes periods when our democratic process was not fully inclusive. Some of those problems were eliminated by the 15th Amendment to the Constitution, which prevented discrimination in the right to vote on the basis of race, and the 19th Amendment, which extended the right to vote to women. But that was imperfect. But as compared to a committee of 9, even an imperfectly democratic constitution with the constraint principle is better on the criteria of democratic legitimacy. The Supreme Court in Argentina consists of only 5 justices. That means that 3 individuals, if they employ a living constitutionalist procedure, have the power to effectively amend the Constitution of Argentina by interpretation. The second dimension of legitimacy that I would like to discuss, the second dimension, the second reason for the constraint principle that I would like to discuss is legitimacy. And the second dimension of legitimacy is transparency. Transparency. The ability for citizens to know the basis for constitutional decisions. And I don't know the situation in Argentina, but I do know the situation in the United States. So, in the United States, a living constitutionalist Supreme Court engages in deception and dissimulation as to the true basis for its decision in 2 ways. First, the justices of the Supreme Court are very reluctant to ever admit that their own moral beliefs and ideology plays a role in their decision. Of course, all the insiders, sophisticated lawyers, know that when the Supreme Court divides 5-4 over and over again, 5 Republicans voting one way, 4 Democrats voting the other way, that political ideology is playing a role in the decisions. But the decisions never disclose the role of the moral and ideological beliefs of the justices. Secondly, when the Supreme Court departs from the constitutional text, it never admits openly that it's doing so. Instead, the court engages in word twisting and feats of circuitous logic to conceal decisions that in effect amend the Constitution. I'll talk about an example of this in a moment. This is not transparent decision making. Originalism makes the basis for constitutional decisions transparent. The basis for decisions is the constitutional text, and every citizen can read the text and compare the decisions of the Supreme Court to the text if they wish to do so. The third important idea is the public meaning thesis. So, the public meaning thesis is the idea that the relevant meaning of the constitutional text is the meaning for the public, for ordinary citizens. The relevant meaning is the ordinary meaning. And there are 3 reasons to believe that the public meaning thesis is historically accurate as a description of constitutional communication in the United States. First, The Constitution itself suggests that its meaning is its public meaning. The first three words of the United States Constitution are "we the people." The United States Constitution in Article 4 commits itself to a republican form of government. The Constitution is a res publica, a public thing. Second, the process of constitutional ratification in the United States is public in nature. In the period between 1787 and ratification of the Constitution, the necessary number of states ratified by 1790, this process of ratification was intensely public. The Constitution was debated and discussed in town meetings. Ordinary citizens gathered together. The full text of the Constitution was read out loud in public meetings. The provisions of the Constitution were debated and discussed by ordinary citizens. These citizens then voted to elect representatives to state ratifying conventions. And it was then those state ratifying conventions that adopted the Constitution, pursuant to Article 7 of the proposed Constitution. Third, the commentators, the writers about the Constitution, and the judges who interpreted the Constitution early in the history of the Republic, over and over again affirmed the proposition that the meaning of the Constitution was its public meaning, its ordinary meaning. Such statements are to be found, for example, in the writings of Chief Justice John Marshall of the Supreme Court, in the famous commentaries on the United States Constitution by Joseph Story. Now, the situation in Argentina is not identical. The Constitution of Argentina was adopted in a convention, and this convention did not involve the same process of popular participation. But there are indications in the Argentine Constitution and in the convention itself that indicate that the Constitution was intended as a public document. I leave that to Argentine scholars to resolve. But this much I think is clear. The Argentine Constitution was not intended to be read only by lawyers. Of course, it was intended to be read by lawyers too, but the delegates to the Constitutional Convention that produced the 1853 Constitution included non-lawyers, and the Constitution was addressed not just to the Supreme Court, but also to the presidency and the executive branch, to the Congress, and these bodies may include lawyers, but they surely are not. They surely do not consist solely of lawyers. So the meaning of the Argentine Constitution also, I think, should be interpreted as an ordinary meaning and not as a technical meaning that can only be accessed by lawyers. The fourth idea that I would like to discuss briefly is the interpretation-construction distinction. This is a technical distinction that has a long history in American legal theory. It goes back to Franz Lieber, a very prominent American lawyer who argued that we should distinguish two distinct activities. The first activity he called interpretation. This is the activity of discovering the meaning of the text. The second activity he called construction. This is the activity that puts that meaning into practice, that determines the legal effect to be given to the constitutional text. So originalists have a distinctive view of interpretation, that interpretation should seek the original public meaning of the constitutional text, and a distinctive view of construction, that construction must be guided by interpretation, guided by the original public meaning, consistent with the original public meaning, but not necessarily fully determined by the original public meaning, because, as I mentioned before, there will always be a need for implementing rules and precisifications, for rules that put the Constitution into action, into particular context. This point is important because it allows us to dispel a myth about originalism. The myth is that constitutional law must be static. That is not the case. Facts change. Circumstances change. The provisions of the Constitution must be applied to new circumstances, and this may require new implementing rules. We have a freedom of speech. It may need to be applied to speech on the internet. That is an implementation that may require new doctrines. Let me give some examples of originalism in action. Let me begin with an example from the United States constitutional history. It's the case of Wickert v. Filburn, a very famous case that interprets the Commerce Clause of the United States Constitution. So the United States Congress has a list of enumerated powers. One of those powers, and the greatest of the powers, is the power to regulate commerce among the several states. As originally understood, and as understood by the Supreme Court for most of our history, this means that this power applies only when the activity to be regulated is commerce, trade in goods. That was the original meaning of commerce, or the means of trade in goods, such as transportation or navigation. And the commerce must be between more than one state. During the New Deal, Congress enacted the Agricultural Adjustment Act. And one of the things the Agricultural Adjustment Act did is regulate the growing of wheat by a farmer on his own farm for his own use. So this statute was challenged, and we now know about the deliberations in the Supreme Court. So this was the New Deal Supreme Court in the 1940s. They had been selected for the Supreme Court because of their support for the New Deal, for President Roosevelt, and they had a real problem. This provision of the Agricultural Adjustment Act looked like it was plainly unconstitutional, but that was not a result that they could reach. They discussed the possibility that in this case they would end judicial review of the statutes enacted by Congress, and seriously considered the end of judicial review in this context. They decided that that course of action was too radical, that this would cause a howl of protest and create serious legitimacy problems for the court. So they chose another alternative. They adopted a new test. It's called the cumulative effects test. And the idea is this, that anything that Congress enacts is a regulation of interstate commerce if it has a significant effect on commerce. But the question would not be whether it actually has a significant effect on commerce as supported by evidence. Instead, the question would be whether it is conceivable that it would have an effect on commerce. Whether a rational Congress, a Congress that was not Looney Tunes, not crazy, not committable to an asylum, could believe that there was a significant effect on interstate commerce. Of course, if that is the test, then all possible regulations are regulations of interstate commerce. And that is the doctrine that I was taught in law school. Things later changed in the 1990s. It's an interesting story. A second example relating to Argentina. So in the paper, I discussed the many forms of living constitutionalism. And as you saw in the paper, there are many, many versions of living constitutionalism. One family of living constitutionalist approaches emphasizes what I call extra-national sources of constitutional law. And one version of this family of theories focuses on international human rights treaties. So in many nations, and I think perhaps Argentina is among them, international treaties are used by Supreme Courts or constitutional courts to create new constitutional doctrines. So, as an originalist, I would have two questions about this procedure. The first question would be whether or not this use of international treaties is consistent with the original meaning of the Constitution of Argentina. So that is a question I believe should be answered by a court that considers itself bound by the Constitution of Argentina. The second question I would ask concerns the interpretation of the conventions by the tribunals charged with their application. So in the case of the American Convention on Human Rights, the relevant tribunal is the Inter-American Court of Human Rights. So from an originalist perspective, I would want to ask the question, does the Inter-American Court follow a procedure of convention originalism, or does the Inter-American Court view its function as involving living conventionalism, interpretations of the American Convention on Human Rights that are not fully consistent with or not fairly traceable to the text of the convention? So these are not questions I can answer, but they're questions that I pose to you. And with that example, I will finish my remarks, and I look forward to your questions, comments, and criticisms.
Buenos días, muchas gracias por su exposición. En primer lugar, quisiera simplemente remarcar que hay muchas de las afirmaciones propuestas del nuevo originalismo que parece que recogen la adhesión de la mayoría de las teorías, no sé si de todas, pero de la gran mayoría, que es que, por ejemplo, los jueces de la Corte Suprema no pueden modificar la Constitución sin seguir el procedimiento establecido para ello, o que es necesario tener en cuenta el contexto lingüístico para interpretar qué significa el texto de la Constitución, o que no se pueden tomar decisiones sin ninguna vinculación con el texto constitucional, me refiero a decisiones constitucionales, ¿no? Pero en concreto, yendo a la propuesta del originalismo, me parece que tiene, y me gustaría conocer su opinión, algunos desafíos. En concreto, la propuesta del originalismo parece buscar cómo evitar que los jueces discutan sobre los valores que le asignan a la práctica constitucional para entender el texto de la Constitución. Y en ese sentido, la propuesta de lograr evitar esto, apelando no al texto constitucional, sino ahora, cuando el texto constitucional tiene una indeterminación lingüística, al contexto en el que fue sancionada esa Constitución, en concreto al contexto lingüístico original, me parece que es difícil que logre resolver de forma definitiva ese problema. De hecho, muchos autores han señalado que intentar de resolver el problema de la indeterminación de un texto jurídico apelando a reglas de interpretación o a nuevos contextos de interpretación, siempre se topa con el problema de la indeterminación de esas reglas de interpretación o de esos nuevos contextos de interpretación. Normalmente este argumento se lo llama el argumento de la indeterminación de segundo grado. Entonces me gustaría conocer en primer lugar su opinión sobre este argumento. En segundo lugar, me parece que el originalismo en realidad lo que busca es proponer una manera de interpretar la Constitución discutiendo los valores que le asignan a la práctica constitucional. En concreto, los valores que en este caso el originalismo, que esta versión del originalismo presentó, son el de rule of law, el de legitimidad, el de transparencia. Por lo tanto, en los intérpretes originalistas hay una discusión acerca de cuáles son los valores que le asignan a la práctica constitucional, y a la luz de los valores que le asignan a la práctica constitucional buscan determinar el significado de ese texto, en algunos casos indeterminado. Y en tercer lugar, si bien coincido que toda interpretación de la Constitución que busca desentrañar su sentido, que busca entender qué quiso normar la Constitución, qué quiso regular con su redacción, sin duda tiene que apelar al texto para desentrañar dicho sentido, y sin duda en algunos casos puede ser útil también apelar al contexto en el que fue sancionado ese texto. La duda que me queda es en los casos en los que hay una indeterminación de segundo grado, en los cuales el texto ni el contexto me resuelve el problema de la indeterminación. Si nos quedamos solo con la propuesta originalista, pareciera que el intérprete ahora se queda sin ninguna respuesta para resolver el problema de la interpretación de esa norma. Nada más, gracias.
Thank you very much. Yes, so questions about underdeterminacy certainly figure prominently in debates about originalism in the United States. This is a general problem in legal theory. So let me address two aspects of underdeterminacy. What you refer to as second order underdeterminacy and first order underdeterminacy. At the end of the day, we need to distinguish between cases of two types. So I want to talk about cases that are in what I will call the interpretation zone. That set of cases for which there is a determinate meaning that resolves the case. So in the case of the United States Constitution, most constitutional provisions, the vast majority of the constitutional text provides clear and relatively determinate rules. There is no dispute about the meaning of most provisions of the United States Constitution. And I'll just give the easiest of the easy cases, right? 2 senators per state. There is no dispute about the meaning of 2 or the meaning of state. The idea that we have a single president and not a plural presidency, as was proposed, no dispute about that. The idea that there must be a Supreme Court, that this is a constitutionally required institution. The basic structure of government is clearly established. And it's not just these super easy cases, but many other cases fall into the zone in which when we do interpretation of the text, it yields a clear and relatively determinate meaning. So those are not the cases that we're worried about. The cases that we're worried about are the cases in which the constitutional text is underdeterminate. first order underdeterminacy, or in which the methods of constitutional interpretation are not fully determinate. Second order underdeterminacy. Now, I use the word underdeterminacy because this is important. Even those provisions and methods that are not fully determinate, that don't give us complete answers to our questions, or don't resolve all of the aspects of a case, may nonetheless rule out many possibilities as inconsistent with the text. So what remains, we might call the construction zone, the zone in which constitutional construction is required in order to resolve the underdeterminacy. Of course, this is the function of judicial decisions that adopt precisifications or implementing rules. So the text of the Constitution, first order underdeterminacy, can be underdeterminate because of vagueness, right? And I use vagueness here in the technical sense in which it refers to constitutional provisions that admit of borderline cases. So there may be things that are clearly legislative power entrusted to Congress, things that are clearly executive power entrusted to the president, things that are clearly judicial power. We might imagine a Venn diagram with 3 circles, but there may be borderline cases where a precisification will be required. Other constitutional provisions may be open-textured in the sense identified by H.L.A. Hart. Again, implementing rules or precisifications will be required. This means that a complete theory of originalism will require a theory of constitutional construction. So working out a theory for the resolution of underdeterminacy is, in fact, an important part of the agenda of originalist constitutional theory, and there's much work being done on this. Here is the approach that I have tentatively adopted. This is a problem that I'm working on now, so I don't pretend to have the final answers to this problem. There's other writers who have more fully developed theories of constitutional construction. Step 1, we determine the purpose or function of the constitutional provision to the extent that we can know what the purpose or function is. Many constitutional provisions have clear functions or purposes. So the first constraint on constitutional construction is to adopt an implementing rule or precisification that is consistent with the purpose. But step 1 is not sufficient, because more than one implementing rule may be consistent with the purpose of the constitutional provision. So step 2, among those implementing rules or precisifications that are consistent with the purpose, select the implementing rule that involves the least departure from the background of existing law. So this, for example, would require the courts to consider precedent, existing constitutional rules acknowledged by precedent, what we call in the United States historical practice, and by this phrase we mean to refer to the constitutionally implicated decisions of Congress or of the presidency or other executive officials. So, and of course there are other background principles of law in the United States, principles of statutory law and common law. We would adopt that among the precisifications or implementing rules, adopt that precisification which is most consistent with existing law. But it's possible now that there are still underdeterminacies that remain. So step 3, If we are unable to resolve the case via step 1 and step 2, then defer to the decisions of elected officials. Then we defer to the decisions of elected officials. In other words, if there is an underdeterminacy that cannot be resolved, where we really are unable to decide what the Constitution requires, then in those circumstances we would adopt a principle of deference. Now, another aspect of your question involves the idea that originalism's values enter into the process of constitutional interpretation and construction. So I have suggested that the justifications for originalism sound in the values of the rule of law and legitimacy. So first, I want to say that as I understand constitutional interpretation in the technical sense, the ascertainment of meaning, the rule of law as a value does not play a role. Interpretation is not a normative enterprise. It is a factual inquiry that seeks to recover a fact, the fact about what content was actually communicated to the public. This is the same kind of fact that we attempt to recover when we interpret any communication, oral or written. There is a fact of the matter as to what someone said. There are special cases of intentional ambiguity. We can talk about those separately, but there is a fact of the matter. Construction must be guided by principles of value, right? And so an originalist theory of constitutional construction must be guided by the same values that justify originalism. So our theory of construction should be responsive to the rule of law and to legitimacy. And so the theory of constitutional construction that I just proposed does do exactly that. So it suggests that first, the precisifications must be consistent with the underlying purpose of the text. They may not undermine the text. You may not do what the Supreme Court did in Wickert v. Filbert, adopt a constitutional construction that, while purporting to interpret the text, actually nullifies the text. That's ruled out. At the second stage, we adopt constructions that involve the minimum achievable departure from existing law, reflecting the rule of law as a fundamental justification for originalism. And at the third step, we defer to democratic institutions, reflecting the underlying justification for originalism by democratic legitimacy. So this is absolutely true. I fully embrace this comment that values do play a role, but they do not play a role at the stage of interpretation. They play a role at the stage of construction. So these were very illuminating questions. Thank you very much.
Muchísimas gracias, profesor, por su interesantísima presentación que nos lleva evidentemente a pensar mucho. En la última parte de la misma, usted hizo una referencia al tema de los tratados internacionales y el derecho interno. En ese sentido, la reforma de 1994 en la Argentina produjo un cambio enorme. Nosotros teníamos el mismo sistema de monismo de la Constitución americana y esto se modificó por un sistema mixto. En realidad es difícil llegar a decir si es dualismo realmente, pero es un sistema en el cual la Constitución establece que los tratados prevalecen sobre las leyes y sobre todo da jerarquía constitucional a un número de tratados internacionales sobre derechos humanos. En uno de esos tratados existe la creación de una jurisdicción internacional, la Comisión Interamericana y la Corte Interamericana de Derechos Humanos. Al respecto ha surgido una gran dificultad entre el valor de las decisiones de los dos órganos a partir del reconocimiento de un control de convencionalidad que se agregaría al control de constitucionalidad y que fue creado en realidad por la misma Corte, en un caso muy conocido, Almonacid Arellano. Lo que yo quisiera preguntarle es, por un lado, en relación a las decisiones de la Corte Suprema de un país, si derecho interno, a través de la jurisprudencia, ¿cuál piensa usted que debería ser la relación con las decisiones de la Corte Interamericana, en particular si se produce una modificación o una anulación de una sentencia de la Corte Suprema que tiene autoridad de cosa juzgada?
Yeah, thank you for the question. And my answer won't be satisfactory, I'm sure, because you have gone far beyond my very superficial knowledge, both of the situation in Argentina and in the jurisprudence of the Inter-American Court of Human Rights. So I can't really provide a direct answer to your question that I would in any way be confident of. What I would like to say is this, that I think that from an originalist perspective, there are two issues here. And one issue is an issue regarding the meaning of the Constitution of Argentina and what exactly the original meaning of the 94 amendments are, right? So this question I'm not competent to comment on. And the other question concerns the original meaning of the convention. And so I think from an originalist perspective, there would be a grave problem with allowing sort of living conventionalism plus a provision that accedes to the decisions of international tribunals interpreting treaties being used to essentially cede control over the constitutional law of Argentina to a living conventionalist approach by the Inter-American Court. But this is really very tentative and speculative on my part, because you have just your question goes far beyond the matters upon which I am competent to comment in an authoritative way.
Thank you very much for your lecture. It was very interesting. I have some troubles with the meaning of the public meaning. As far as I understood, public meaning means the ordinary words or the ordinary understanding of the words of the Constitution. But can't this be also claimed by the living constitutional theory? Because the Constitution is a public instrument, it's aimed to the public, it rules the government, it rules the relationship between the government and the people, and the words, the public words of the Constitution, perhaps are aimed not only to the original intent or the original theory, but also to the living Constitution theory, because they are public, they are ordinary words. That's why I can't understand really the meaning of the public meaning.
Okay, thank you very much for this question. So the question goes to the nature of public meaning. And so let me talk about the originalist position and the living constitutionalist alternative. So the originalist position is that the relevant public meaning is the public meaning of the constitutional text at the time the text is framed and ratified, at the time the text is written. Why do we look to that meaning rather than contemporary meaning? So the originalist argument is that this is the way communication works, that the meaning of a text is not a new meaning assigned to it by later readers, that the actual meaning of the text itself is the meaning produced at the time it was written. So if we were not talking about a constitution, let's suppose we're talking about another document. We have a letter that was written in 1853. We want to know, what does this letter mean? Well, what would we want to know? What would we need to know then? Well, we would read the letter, and we would look at the words and phrases, and if we were in doubt, we would ask ourselves, wait a second, do these words in this letter mean the same thing in 1853 as they do now? And if there had been a linguistic change, no one would say, well, the letter, the meaning of this letter in 1853, which used the phrase domestic violence, that means spouse abuse, even though that phrase did not have that meaning in 1853. That no one would sensibly interpret a text in that way. Okay, so that's the originalist perspective, that as a question of interpretation, meaning is fixed because a text, the author of a text, the ratifiers of a text cannot ratify a future meaning. They can only ratify and create a meaning that is fixed in their time. So there is a living constitutionalist position that takes a different approach. Sometimes this is called contemporary ratification theory. This approach is associated with Justice William Brennan, a very great justice of the United States Supreme Court. He wrote an essay called The Living Constitution that he delivered at Georgetown University, at my university, in the 1980s. Very great lecture. So here was his proposal. His proposal is that the Constitution should not be viewed as having been ratified by the ratifying conventions, that constitutional amendments are not ratified by the states as provided by Article 7 and Article 5 of the United States Constitution, that the Constitution is ratified every day by the people of the United States. Its legitimacy derives from contemporary ratification, and so the relevant meaning is the meaning of the words to ordinary citizens today. This is the position that you have advanced. So notice, however, three things about this position. First, this means that linguistic accidents produce constitutional amendments. That if the meaning of a word has changed, the meaning of the Constitution changes. I once wrote an essay about, I have an essay about the fixation thesis, right? And it involves a hypothetical that's intended to illustrate the problem here. So in the hypothetical, a rap artist has a very, very popular song in which he uses the phrase freedom of speech to mean police violence. This song is so popular that ordinary citizens, when they hear the phrase freedom of speech, they think, that's the freedom of police officers to inflict violence on innocent civilians. So the contemporary ratification theory would say that if enough citizens come to believe that this is the meaning of freedom of speech, then the First Amendment of the United States Constitution is no longer about freedom of expression, it's about the freedom of police officers to inflict violence. You know, you may think that this kind of hypothetical is far-fetched, but it turns out that I didn't know this when I wrote the article, but that the rap singer Eminem, the American rap artist Eminem, wrote a song called "Stan" about a fan, and the word "stan" has now entered into ordinary English to mean what Eminem said it means in the song. So to stan someone is to be an obnoxious fan. So this hypothetical, which I thought was a little bit on the wild side, is perhaps not so wild after all. Second issue. The Supreme Court, the living constitutionalist Supreme Court, does not actually do this. The Supreme Court does not inquire into the meaning of the words of the Constitution for ordinary citizens today. This is not what Justice Brennan did. He provided this as a theory to justify what he was doing, but his theory did not justify what he was doing. He was not looking to ordinary citizens to make his constitutional decisions. He was making his constitutional decisions based on his beliefs about what a just constitutional order would be, not about the beliefs of ordinary citizens. The beliefs of ordinary citizens would not have resulted in Brown v. Board of Education. American opinion in 1954, it changed subsequently, but in 1954 did not support the Supreme Court's decision in Brown v. Board of Education. The opinion of the American people did not support, for example, the Supreme Court's decision in Miranda versus Arizona. This is the famous decision, you have the right to remain silent, etc. So this version of living constitutionalism is not the version of living constitutionalism actually practiced by the very justice who proposed the theory. Third, what this theory actually is intended to do is to legitimate Supreme Court decisions that later come to be accepted by the public as providing the meaning of the Constitution. So, and this process can be very effective. The Supreme Court's interpretation of the Equal Protection of the Laws Clause has completely transformed the meaning of that clause with the public. So the original Equal Protection of the Laws Clause, in the drafting process, the word equal was added at the very end. It was originally the Protection of the Laws Clause. And the idea of this clause was to provide Congress power to make sure that state governments protected the former slaves from violence, theft, and fraud. Right? So that there was a great worry, and the history, right, immediately after the end of the Civil War was replete with examples, was that the state governments would not prevent the murder of the former slaves, that the state governments would not prevent mayhem against the former slaves, theft from the former slaves, fraud, and breaches of contracts involving the former slaves. So the Protection of the Laws Clause was designed to empower the federal government to protect and to create an obligation on state governments to provide this protection to all persons. That was the purpose of the clause. Supreme Court nullified that part. In a famous case, DeShaney, the Supreme Court says equal protection has nothing to do with the protection of the laws. Now, and it invented, over the course of many decades, a whole other function for the protection of the laws clause. So this contemporary ratification theory, what it actually does is enable the Supreme Court to amend the Constitution and then say, well, our interpretation of the Constitution has now changed the way that ordinary citizens understand the Constitution, so now that is the meaning of the Constitution. Now, if you like what the Supreme Court has done, then you'll like this idea. If you trust the Supreme Court always to make good decisions, then you might think that this is a really good way to make constitutional law. But I think that this way of making constitutional law is profoundly dangerous because there is no guarantee that the Supreme Court will always share my values. I was a Dworkinian. I thought moral readings, hooray. Right? Especially attractive theory for law professors. My moral readings are the meaning of the Constitution. It's thrilling. I do moral philosophy, and then I try to convince the courts that the Constitution means what I believe it ought to mean. But I became very nervous about Dworkin's approach in the 1990s when it became apparent to me that there was a strong likelihood that the Supreme Court would have a majority for decades to come of justices with the values of whom I did not approve. Right? So I'm a sort of a in my politics, not in my judicial philosophy, but in my politics, I'm sort of a liberal, progressive Democrat. And of course, the situation today is in flux. Things could go all kinds of ways, but here's one way it could go. Both Justice Ginsburg and Justice Breyer could be replaced by Donald Trump, with extremely conservative justices in their 40s or 50s. There are rumors that both Samuel Alito and Clarence Thomas will resign so that they can be replaced by justices in their 40s and 50s. If that happened, the United States Supreme Court would have a very, very conservative majority for the next 35 to 40 years. I would much rather that court be an originalist court than that it be a Dworkinian moral readings court, importing the conservative values of the justices and turning those values into constitutional law. So I'm very nervous about this idea of contemporary ratification. It is a very clever idea, a very seductive idea, an idea that once attracted me very much, but I'm now very skeptical of this idea. I have come to believe it is a very dangerous idea.
You have to put words in context in order to try to determine the meaning of the words. There is a criticism, and this goes back to a discussion, friendly discussion that we had with Pedro, that you may be mixing, an originalist may be mixing context with intent of those who wrote the law or wrote the Constitution. And let me give you an example, a local example. Our Constitution, Section 2, states that the federal government supports the Roman Catholic Church. The word support is not very precise. It could mean many things. It could mean moral support. It could mean that actually it seems to be like an official religion. Somebody could say that. I disagree with that, but they could argue that. And it could also mean that it has the obligation of support the church economically. If you go to the discussions of the convention, it is clear that what they meant was, or their intent was to reflect that
the Roman Catholic Church should be economically supported by the federal government. But the point is that the intent of the framers that was not actually reflected in the words, or is that the context in which those words were included in the Constitution? So what would be your idea of how can we answer that criticism to originalism?
Thank you. So the question has to do with the relationship between context and intent in constitutional interpretation, and we're setting construction to the side for the moment. Okay. So let me first state what I take to be my position and the sort of the mainstream originalist position on the role of context in a case like this. So we have the semantics of the relevant constitutional provision. If we just looked at the semantics, that is, we don't consider context, then the meaning is quite sparse, because the word support is both vague and ambiguous. It's vague because there can be degrees of support, and what degree of support would constitute fulfillment of the constitutional obligation. It's ambiguous because the word support has multiple meanings or senses. Financial support is one sense of the word support, but there are other things that could also be senses of the word support. So the problem that you identify is a problem of ambiguity. After we resolve the ambiguity, then we would have to deal with the vagueness. That would be in the construction zone. But your problem is the problem of ambiguity. So context must be considered in resolving ambiguity. This is the way we normally deal with an ambiguous text. So we have a statute. The statute uses it's an English statute. It's a statute written in English, so it uses the word bank. In English, the word bank has multiple meanings, one of which refers to financial institutions, right? The banks where you deposit money. The other of which refers to the bank of a river. The river bank is the soil that abuts or adjoins a river. Now, when you read the word bank in a statute, you almost always, maybe every single time, know what the word means, which sense is intended from the context. If it's a statute dealing with financial institutions, then it's not a river bank, it's a financial institution. What context do we consider? What context do we consider? So obviously, everyone knows we, at a minimum, consider the surrounding words. So we would look at the first context we would examine would be the entire context of the constitutional text, the 1853 Constitution. But just reading the 1853 Constitution is not sufficient to resolve this ambiguity. Now we have to think about what I call the situation of constitutional communication. So the situation of constitutional communication, who was writing for whom? Who was writing for whom? In other words, the people who drafted the 1853 text, who were they drafting for? The convention. But not just for the convention, but also for the people who would implement the constitutional text. So in the case of the 1853 Constitution, and now I'm just going beyond certain knowledge, and I'm really relying on things I've just heard and picked up over the last week. So excuse me if this is wrong. The 1853 Constitution, the deliberations of the convention and the report produced by the convention, right, and the sort of the basic situation that was being addressed, the role of the church, the background of state support or not support for the church, all of that would have been part of the context of constitutional communication, given the situation in which the Constitution was drafted and ratified and put into effect. So the question that I would want to ask is, does that context disambiguate the word support? And based on the discussions of this particular problem that I've heard, but not based on any knowledge of my own, right? I really don't know anything. But based on the conversations I've heard, it seems to me that it's at least plausible that support would have been understood in its financial sense. Same sense, in the United States we have the phrase child support to discuss the financial support of children, and that's the financial sense of support. So if that's the case, if the context of constitutional communication does suffice to disambiguate, then we would have our answer, and originalism would take the position that that answer should be binding. I just want to point out that many non-originalists have a different approach here. So Ronald Dworkin, in his final book, Justice for Hedgehogs, introduced a new element into his theory. It's very interesting and very revealing. So he uses the phrase semantic availability. Semantic availability. So what Dworkin is doing is saying that when judges interpret a constitution, they are required to use meanings that are semantically available. Another theorist who has taken the same approach is my former professor and dear friend, Richard Fallon, and also the sort of the great constitutional theorist and administrative law scholar Cass Sunstein. They have argued that for a form of living constitutionalism based on the idea of multiple meanings, so it goes something like this. Yes, there is the original meaning. That's one meaning. But there's also the literal, acontextual meaning of the constitutional text, the pure semantic meaning, what Ronald Dworkin calls the semantically available interpretations. And then there are other meanings too, the reasonable meaning, the meaning that the Constitution would have had if it had been produced by a reasonable constitutional convention of good persons producing a constitution that that approximated the ideal. And then there is the sort of the moral conceptual meaning. This is Ronald Dworkin's idea of the concept-conception distinction, and that a constitution might include general concepts, and it's the duty of judges to select the best conception of the concept. So and they have other meanings too. They have a whole list of meanings. And then they say judges are permitted to select any meaning that they believe, for normative reasons, would be the best meaning to resolve the particular case or the particular issue. So a Dworkin or Fallon or Sunstein reacting to this example might say, we have this word, support. A semantically available meaning is that support means to cheerlead. To sort of generally say, rah, rah, Catholic Church. We like you. Or a much more conservative Catholic judge might say, support. That means to establish the church as the state religion. That's the mandatory state religion. Now that would run into intertextual problems because there's a freedom of religion, right? But to establish the religion while allowing others to practice their religion. So both of those interpretations are semantically available. And this criterion of semantic availability produces a constitutional meaning that is very, very sparse or thin. Sparse or thin, these are the metaphors we use to establish the idea that semantic meanings, literal meanings, create tremendous freedom for judges. So the idea that we would just use the semantics, this is something that originalists must oppose. To be an originalist means that you must take context into account in constitutional interpretation.
Thank you very much for your presentation, Professor. My question has to do with public meaning thesis also. I'm concerned with that concept. My question will be upon the remarks made by Professor Bianchi. You say that not all legal texts communicate to the public, and I think this idea is quite controversial, and maybe we have to define what you mean by legal to the extent that you refer only to laws or other kind of legal materials.
So just a second. I don't think, I just want to make sure we're on the same page. Just to clarify before you go any further, I don't claim that all legal texts have public meaning. It depends on the text. So some statutes communicate only to a specialized group, regulated industries and regulators. Many contracts are designed only to be read by the parties and perhaps also by judges. So just my claim is only that the United States Constitution has public meaning. So.
Thanks for the clarification. I understand that and I share that. But my question is, how can one consider that a constitution is not intended to communicate to the public, as the constitution is the basic material, the basic normative material that is intended to regulate the life of the people in a nation? Because you say that in order to apply the public meaning thesis to any legal order or system, we need to make we need to investigate this from a historical point of view. But my question is, isn't this something from that will have to be decided from a dogmatic point of view? Any constitution is intended to communicate to the people.
I wish that were the case. So I would argue, you could make an argument that in constitutional democracies, there is a normative requirement, a normative standard, and that constitutions in all constitutional democracies should communicate to the public, right? So I would accept that premise. Now, not all societies are constitutional democracies. So in a society that is not democratic in nature, it's perfectly conceivable that there would be a constitution that was written only for the oligarchy, right? This is a constitution of the oligarchs, for the oligarchs, by the oligarchs. It's not a public constitution. So this would at least be a possible option. Let me present the contrary view regarding public meaning in the United States. I want to make it clear. I think that the view I am about to describe is wrong. But it is a view that has been advanced in the United States. So two originalists, Michael Rappaport and John McGinnis, have taken the position that the United States Constitution does not have a public meaning and is not comprehensible by the public, that ordinary people cannot understand the Constitution. So their theory is that the United States Constitution was written in a special language, which they call the language of the law, that can only be understood by lawyers. Now, I don't think that that hypothesis is plausible. Right? That's not a plausible hypothesis, I believe. For one thing, I think that it's based on bad linguistics. In linguistics, there is a phenomenon called diglossia, where two languages are spoke in the same geographic territory, and so there are, for example, certain societies in which Arabic is spoken in two different forms. High Arabic, which is archaic and uses words and constructions that are not accessible to ordinary folk, and sort of the regular Arabic, the Arabic that's spoken on the streets. I just think that it is utterly implausible to think that there were two different languages spoken in the United States in 1787. Legalese only spoken by lawyers and American English spoken by everyone else. I do want to say the one thing, which is that I think it is okay for a constitution to use some technical language as long as it's clear to ordinary citizens that the language is technical in nature. So in the United States Constitution, Congress is authorized to issue letters of marque and reprisal. So this provision has no effect anymore because they don't exist. But a letter of marque and reprisal was a commission given to a private warship to prey on the trade of an enemy during times of war. It sort of legalized piracy, but only the trade of the enemy and only during times of war. Well, okay, so you have a similar provision. So this provision has not been used for a very long time. But citizens in 1787, my guess is that if you did not live in a port community like Boston or Charleston, that the idea of a letter of marque and reprisal would just have no meaning to you. It just, people in the interior would have no reason to ever discuss this. But nonetheless, because it's clear that this is a technical term, an ordinary citizen could go to the library or ask a lawyer or write a letter inquiring as to the meaning of this phrase, because the technical nature of the words is accessible. McGinnis and Rappaport have a much more radical thesis. They believe every word in the Constitution has a technical meaning and that only lawyers can read the Constitution.
La teoría originalista me resulta muy atractiva, pero me surge una duda en relación con el stare decisis. Sé que en Estados Unidos el precedente constitucional tiende a ser más flexible que quizás que otro tipo de precedentes, pero quisiera saber concretamente si usted piensa que sería deseable abandonar una interpretación proveniente del living constitutionalism, aun si eso implicara abandonar un precedente de la Suprema Corte consolidado.
Yes. Okay. So Oh, I need the mic. So this is a really excellent question, the relationship between originalism and precedent. This question is very, very important because in the United States there is so much living constitutionalist precedent that it would be just impossible to overthrow all of it all at the same time. So no sensible originalist advocates what I call an originalist big bang. So one super term of the Supreme Court in which the court grants certiorari in 1,000 cases and restores the original meaning of every provision all at once. There's just too much law that would have to be changed. So there must be a transition period in order for originalism to be practical. And I view this as a phased process. So I want to talk about the status quo. So we're not in the transition now, right? There's two originalists on the Supreme Court. Maybe Brett Kavanaugh's an originalist, maybe not, who knows, right? It's too early to tell. Sam Alito is definitely not an originalist. He's never written an originalist opinion, never used originalism in an opinion. He goes around saying, I'm an originalist, but then he never actually does anything that's originalist. So I don't think he's an originalist. John Roberts is hostile to originalism. And then all four liberal members of the court, Kagan, Sotomayor, Ginsburg, and Breyer, are clearly living constitutionalists. So in my opinion, it's either 7-2 or 6-3 living constitutionalists. So we're not in the transition now. But suppose that one day there were a majority of 5 originalist justices on the court. How should they behave? I think that we need to think about this in phases. Phase 1, this far and no further. So in phase 1, the Supreme Court would not invalidate existing statutes that are based on non-originalist precedents. Instead, the court would prevent the passage of new statutes that were inconsistent with the original meaning of the constitutional text. So in American constitutional doctrine, this approach would be represented by 2 cases from the 1990s, United States versus Lopez and United States versus Morrison. These are cases that provided a very minor limit, but a limit on the expansion of the Commerce Clause. And the proposal in the Obamacare case, in NFIB versus Sebelius, was that the Obamacare legislation would not be allowed because it involved a new kind of regulation of interstate commerce, the individual mandate, and the argument was that this kind of regulation had never been done before. So the first phase would be we would not allow any new violations, but that we would leave existing precedent in place. Phase 2. In phase 2, the Supreme Court would begin to invalidate unconstitutional precedents that were contrary to original meaning in cases in which there was not a substantial reliance interest. Right? So in some cases, the invalidation of a precedent is going to have tremendous practical consequences. But there are many cases in which original meaning can be restored without damage to reliance interest. So in phase 2, we would begin to roll back unconstitutional precedents. Phase 3. At some point, it begins to become clear to the system, the political system, the president, the voters, the Congress, what the Supreme Court is up to, that you have an originalist majority and that they are gradually moving the law towards original meaning. So during that phase, the Supreme Court might begin to make decisions that would warn the political system that certain precedents are now under consideration for reversal. So the court might say something like the following. There is quite a bit of New Deal legislation that creates independent administrative agencies. These agencies are not answerable to the president, and Article 2 of the Constitution grants the executive power to the president. These agencies have been entrusted with legislative power. They can actually make laws. The Constitution vests the legislative power in Article 1 in Congress, and these agencies have judicial power. They can resolve disputes between private parties. The Constitution vests that power in the judicial branch. That looks to us like it's unconstitutional. We are now prepared to reverse decisions made in the late 1930s and 1940s concerning these agencies. This is something that we believe may be required by the original meaning of the constitutional text. But we are not doing that today. We are not doing that today. And these decisions would then signal to the political system that the time has come to fix things. Now, things can be fixed in a number of ways. For example, if we truly believe as a society that independent regulatory agencies are required to make government work, many people believe that. If there is a consensus that supports that idea, then we should amend the Constitution to regularize the independent regulatory agency with legislative, executive, and judicial power, independent of the president and the Congress. If that's what we want, we should pass a constitutional amendment. If it's not what we want, if the society cannot form a consensus, then Congress needs to think about ways to fix the independent regulatory agencies. And there are fixes that are imminently doable, that can be accomplished. Let me just give 2 examples of fixes. Fix number 1, make independent regulatory agencies responsive to the president through a power of removal. Fix number 2, give give administrative law judges who are currently located in the executive, they're Article 2 judges, give them Article 3 protections. That is, make administrative law judges federal judges, appointed by the president, confirmed by Congress with lifetime tenure. So much of the machinery of the administrative state can be reformed in a way that would make it comply with the Constitution. So that's phase 3. Phase 4. We actually do begin to strike down precedents that are significant, long-standing precedents, to the extent that it is possible to do so. So now, you may recognize that I'm now, this is sort of, we would say in English, weaselly right? I'm giving myself a little bit of an escape hatch here. No one wants to overrule a precedent that would immediately result in economic chaos, right? So the court ought to have the ability to stay its hand. And it might be that in those circumstances, that the best the court can do is a partial restoration of original meaning via a compromise construction that moves judicial doctrine as close as is feasible to the original meaning. Right now, I have to say, right, I've just come up with 4 phases, right? So, but I'll be dead by phase 4. It will be for another generation of lawyers to figure out the actual mechanism for originalism in phase 4. Phase 4 is not 5 years away or 10 years away or 20 years away. Phase 4 is 40 years away or 50 years away or 60 years away, and it may never occur. It may never occur because the constitutional practice of the United States may remain living constitutionalist forever. I would be sad if that were the case, because I think that was actually a grim future, but it is certainly a possible future. So, but the 4-phase scheme is the way that I believe that you can realistically implement originalism in a way that would not undermine the rule of law and democratic legitimacy. Originalism needs to be implemented in a way that is consistent with the values that justify the constraint principle. So the implementation of originalism must pay heed to legitimacy and to the rule of law.
I want to talk a little bit about the interpretation-construction distinction. It looks to me that that distinction provides conceptual clarity to, on the one hand, to determine the activity of, gaining the communicative content of the constitutional text, and then differentiate the other activity, which is to give legal effect to that constitutional text, which is the construction phase. But there is a danger with this distinction, and I think that that danger is if you have a very thin view of the content of the communicative content, then you will probably have a very thick view of the construction zone. And some of the scholars that are normally, especially philosophers of law that deals with the constitutional text, normally claim that there are many provisions in the Constitution that they're highly abstract. And abstraction is a ladder that can take you into the clouds, so you can, if you climb high enough, you can argue, for example, that the croaking of a frog is the same as the singing of a great soprano because both generates airwaves. But, and this is the question that I have to you, I think that if you provide the historical research, if you do the actual work that you need to do to recreate the context that give meaning to the content, if you provide what you call the contextual enrichment of the text, then many of the provisions that many philosophers of law claim that they're highly abstract are not really that abstract. So my question is, how important is history for originalism in terms of recreating the contextual enrichment to give meaning to the text? Does that make sense?
Yes. So let me make 3 comments here. So I agree with the remarks, but let me make 3 comments. So the first comment is that the idea that thin meaning creates a big construction zone is absolutely correct. And so in American constitutional theory today, Jack Balkin, my dear friend, right, has a book, a very good book, which I recommend to you, Living Originalism. But the way that his theory works is that he limits original meaning to semantics. And he allows for no contextual enrichment. He doesn't allow context to fill in the gaps, the unstated premises of the text. He only allows contextual disambiguation using the immediate context of the Constitution itself. So that results in a very thin or sparse meaning in a very big construction zone. Example, the word commerce, there is a semantically available meaning of commerce that refers to social interaction. Now, if that's the meaning of the word commerce in the Commerce Clause, then the Commerce Clause becomes the regulation of all human interaction. It becomes a virtually unlimited power. But that's the interpretation Jack Balkin has. That means now that his approach to construction, which is very similar to the theory of Ronald Dworkin, allows the Supreme Court to adopt a very expansive conception of national power. So that's the first comment. The second comment is that history is absolutely crucial to the recreation of meaning, right? The only way to recreate the meaning of a constitutional provision, an old provision, is to put yourself in the shoes of the people who were reading it at the time. And that means you need to know about the situation of constitutional communication. And an example of this is the support provision in the Constitution of Argentina that we discussed earlier. If you don't know the history, the semantics are very thin. You must know the history to know what the meaning is. I don't know what the meaning is, but I do know that you need to know the history to know what it is. So that's point number 2. So point number 3, though, is history is important. But this does not mean that the relevant history can only be known by professional historians, right? So in the United States, there are a lot of controversies between historians and originalists. And the position of many historians is that in order to understand history, you have to be a professional historian. You have to live and breathe the period all the time. You must immerse yourself in archives. You can't know history unless you go to the archives and discover new sources that no one else has read, right? So I think that what historians believe about how to do history is completely applicable to doing high-quality history. These are appropriate standards for professional historians. But professional historians are usually not interested in the questions that lawyers are interested in. It's very rare to find a professional historian writing about the constitutional period trying to figure out the semantics and contextual enrichments that would give us the communicative content of the constitutional text. They're interested in very interesting questions, like why were people in Charleston, South Carolina against the Constitution? Why were the people in rural Massachusetts for the Constitution? What were the different constellations of interests in politics that produce those patterns. But those questions are not the questions that lawyers need to answer, usually. Usually, we are concerned with much narrower questions that we can answer by doing good work on semantics, by doing the best possible work about the meaning of the words at the times, and by investigating the constitutional record. Not to say we shouldn't talk to the historians, we should. But just because history is relevant does not mean that lawyers and judges and legal scholars cannot do the appropriate kind of historical investigation.
I'm going to make some closing remarks here, because otherwise nobody's going to say this. First, I want to thank Professor Solum. This has been a very productive week, a very intense week for you, because you've given lectures all over Buenos Aires in many universities. Perhaps you may not know this, but this was a joint effort of the Universidad Austral and the Universidad de San Andrés, which provided the funding and the generosity of Professor Solum, who was willing to partially fund this trip to Argentina. I want to thank the generosity of Pedro Caminos, who had the contact with Lawrence Solum and was very generous in passing that contact to Manuel and myself so that we could organize this. And finally, a special mention to the Dean of the School of Law of the Universidad Austral, who had basically all the responsibility. He took the responsibility of organizing this visit, and this visit, I think he did it so well that this was a great success. So thank you, Manuel, thank you, Larry, again, and thank you all for coming and being here.